So when you're looking at custody in Florida, technically that's not a term that's recognized by the law. So you will hear us commonly refer to time sharing, which is essentially custody. There are different types of time sharing that you can look at depending on your situation. So since July of 2023, there is now a presumption in the law for 50-50 time sharing. And 50-50 time sharing can look a million different ways. Some people do a week on, week off split. That's the most common that we see. There's also 2-2-3 split. I've seen 5-2 splits. It just kind of depends on what works with your particular situation and your schedule. Considering that the law now has a presumption for 50-50 time sharing, meaning that the law considers that to be in the best interest of your child or your children, you can pretty much guarantee that that's what you're going to end up with, unless there are a couple different ways that the court would move away from 50-50 time sharing. One of those being the proximity that you live to the other party. When the parties live close together, 50-50 is usually pretty practical because you both live near the child's school or their extracurricular activities, those sorts of things, so it's usually not a problem. When the parties live further away, most courts would consider like 150 miles or further away from each other. Then they're going to move into what they call long distance time sharing guidelines. With long distance, it's different for each county or each circuit, but typically what that looks like is one weekend a month. If the month encompasses a 3-day weekend, it will usually be that weekend. And then that party will usually end up with summers and then half of Christmas break. So when the courts are looking at determining custody, they're looking at what they consider to be the best interest of your child or your children. So the Florida statutes has a list of several factors that they consider to determine whether or not they believe that whatever time sharing that they're awarding is in the best interest of your child. So some examples of that would be the morality of the parents. Which parent is more likely to foster a close parent-child relationship to the other parent? Which parent has typically cared for the child? Which parent has the time to care for the child or the children? There are several different things that come into play, and every case is different depending on your specific situation. In order to change custody orders in Florida, you would have to file what's called a supplemental petition for modification. In order to get a modification of custody, essentially what you have to show the court is that there has been a substantial change in circumstances and that change warrants a modification and that it's in the best interest of the minor children. So in Florida, once a time sharing order has come out, essentially at that point, there is a statute that kicks in that says that you are no longer allowed to relocate further than 50 miles away from your principal residence. That is as the crow flies, not by driving distance. Essentially, if you are seeking to relocate, you file a petition to relocate with the court, laying out where you're relocating to, why you're relocating, why it's in the best interest of your child or your children. And then that has to be served on the other party. The other party then has 20 days to file a verified objection. And if they don't, then it's considered that relocation's in the best interest of your child or your children. And if they do, then at that point, you would set it for a hearing and go before the judge to present your case. If you have any questions about custody, time sharing, parental responsibility, or anything related to your children at all, feel free to contact us at Cooper & Cooper PA, and we'd be happy to discuss your options with you.